Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you tonight with some more definitions. We're going to talk about bail and various other terms that start with bail. And hopefully people will get some kind of discernment through the program, through the stream tonight, and these definitions of what's really happening with the, quote, commercial paper, which is considered to be property. So let's take a look at bail first. Since bail is the root of what we're talking about tonight, and again, we're going to, is it still stuttering? If it's still stuttering, somebody let me know. If so, I can unplug my stuff and replug it and see how that goes. Is it still stuttering? Norm Longstaff says it's okay, Joseph, so it might be stuttering on your end. Okay, so let's get into this. Again, definition of bail, and we're looking at bail from L.I.I.W.E.X., Cornell Law School. And it says bail is the money a defendant pays as a guarantee that they will show up in court at a later date. And notice it's defendant. A failure to return triggers the bond obligation and allows the court to keep any money given as security. So money itself is a security. Look at that $1 bill and see the seals on it. Those seals convey full faith and credit, and that is because it is a security already. According to the American Bar Association, the judge or magistrate decides the amount of the bail by weighing many factors. In other words, according to the American Bar Association, the judge or magistrate decides the amount of bail. This is the same thing as deciding the value of anything, and it's known as a saying, A-S-S-A-Y-I-N-G, as saying. Just like as set. If it's already set, then why is there a need for a judge to decide the amount himself? Well, because there are other factors. The risk of the defendant fleeing, the type of crime alleged, the dangerousness of defendants, and the safety of the community. All for your safety, folks. All for the safety of the slaves. So, sometimes bail is conditioned on certain behavior of the defendant. For example, that they have no contact with the alleged victim and a failure to return. In other words, if they set you up for a court appearance, you have to appear. You have to return. Okay? So a failure to return to the court triggers the obligation and allows the court to keep any money given as security. Then what they do is they send out another bond to go get you and make you appear. Okay? So let's take a look at defendant as they define it here, and I'm sure many of you have heard me define it by etymological deconstruction, or let's just call it, let's not even call it etymological, let's just call it deconstruction of the term by finding the root word, which is fend, which is a verb. Okay, and then defend has a prefix set on it that places it, that dispositions the verb and makes it a adjective. Then when you put the suffix on it at the end, it converts it again into a noun. So what we have in the end is what's known as an abstract noun, which means it's total fiction. The defendant is a total fiction. And again, you can ask any English major this. Because a man, a living soul as a noun, is a concrete noun. In other words, it has form and substance that can be seen, heard, touched, smelled, and tasted if you want. So let's get back to it. As defendant defined in LII-WEC, defendant in criminal cases is the person accused of the crime. In civil cases, the defendant is the person or entity that is being sued by the plaintiff. In certain types of actions, the defendant is called the respondent, because you respond. Now remember our look at the Federal Reserve definitions and stuff the other day in respondent and correspondent. Okay? However, the term respondent is usually used to designate the person responding to an appeal. So let's take a look at person here. Under the law, a person can sue and be sued, can own property, and can enter into contracts. The term person here includes both natural person and legal person. So what's the difference between a natural person and a legal person? The natural person is a living human being. It's the living soul. Legal systems can attach rights and duties to natural persons without their express consent. Excuse me? Excuse me? That seems to be in violation of the 9th Amendment, wherein the rights of the people aren't actually enumerated. And yet here they're saying that they can do that. If you don't get the context of what's being said there, let's look at it again. A natural person is a living human being. Legal systems can attach rights and duties to natural persons without their express consent. Are you willing to believe that? Are you willing to believe that a legal system operated by other men can place rights and duties on you, saying they have authority over you? That sounds just like my mother standing there at 50 years of age, or when I was 50 years of age, she was much older. She was in her 70s, and telling me that, Keith, the police are your authority. No, they're not. No, they're not. I beg to differ. And if anybody wants to drag me into court on this, again, we'll get that English major out and show them how their supposed ability to place rights, duties, and other obligations as such on natural persons without their consent is not true. In no way can it be true, particularly if that legal system is based on the laws of the United States, which the United States is a corporation. And as we were discussing in other panels various times about capitalism, see, the capitalism is based on the capital. Now, what is the capital? Well, what's the capital of the United States? Washington, D.C. No, Washington, D.C. is the place where the United States is located, and it is a capitalism procuration for the federal government as a corporation for competitive contracting. Now, if you want to compete, then you consent. If you don't want to compete, then you don't consent. So don't sit there and try to placate that this particular definition or pursuance of enslaving the minds of other people is true. It cannot be true that a natural person is a living human being and that a legal system can attach rights and duties without their express consent. See, that's the problem with those whole system. The concept of a natural person appears in business law. Goodness gracious. Let's read that again. The concept of a natural person appears in business law. Did you appear? The legal person might appear. It appears in the record. But can that legal person really be visible in real life as a living human being? No. Can the natural person be seen as a living human being? By this, they say yes. The concept of a natural person appears in business law and bankruptcy law, where it provides a contrast with an artificial person or a legal person, which is an entity that is treated as a person for legal purposes. So let's go back up here. It says, legal systems can attach rights and duties to natural persons without their consent. Yet here it says it's business law and bankruptcy law, where it provides a contrast with an artificial person or a legal person, which is an entity that is treated as a person for legal purposes. While natural person describes an actual human being, artificial person describes a partnership, corporation, or some other entity that has been provided with legal personhood by statute. By statute. So where is the natural person by statute? If they say legal systems can attach rights and duties to natural persons without their express consent, then it must be done by statute. Have to be given knowledge. So we see the natural person is being construed as having some obligation that they don't know about without their consent. So let's back up now. And we have entity. This is back at defendant. And we have entity. An entity refers to a person or organization possessing separate and distinct legal rights, such as an individual, partnership, or corporation. An entity can, among other things, own property, engage in business, enter into contracts, pay taxes, sue, and be sued. An entity is capable of operating legally. Legally, not lawfully. And remember, legal means a licensing to do that which would otherwise be illegal. And even if it's illegal, it does not say anything about unlawful or lawful. See, it's illegal to drive anywhere without a license. It is not illegal to transit from point A to point B, as your God-given rights told you. You have 2 feet that can move and you can decide where to move. You don't need consent to do so. And in so doing so, you are preserved the right to go out and come in by your Lord, God. Suing and making decisions through agents, e.g., a corporation, a state, or an association, telling us that you don't have individual choice. See, those things, suing and making decisions, are done through, not by yourself, but by through agents such as corporations, states, or associations. A legal entity corresponds to the notion of a legal person. A legal entity holds rights, and each entity has a legal status. Now let's look at security. Security refers to a broad type of investments. Security refers to a broad type of investments. I'm already vested in the full armor of God. I'm already vested. Why would I need to invest in a fictional legal system at all? In order to do so, you have to give up your full armor to then invest in their armor. This is David and Goliath. See, David didn't take upon the state, an agent, or an association and their armor. He stood under his full faith of God and his natural talents. And he didn't need the consent. Not only did he not need consent of the people, but the people were willing to let him give it his shot. Because Goliath had already scared the shit out of every other last one of them. And David was the only one out of all of them that had the full armor of God. This is your security. If you're a bitch-ass slave, then this is your security that are regulated under securities laws. With risk management, that is. And remember what I told you about everything is an insurance scheme. There comes a risk with everything you do in this system, and therefore it has to be insured, which is the taking up of a surety, which again, the scripture tells us you're not supposed to do. He that hateth suretyship is sure. Securities exist in numerous forms, including notes, stocks, treasury stocks, bonds, and certificates of interest or participation in profit-sharing agreements. Profit-sharing agreements. So let me ask you about the court registry investment system where you place bail. Is that or is that not an investment? Is it or is it not supposed to be a investment or a profit-sharing agreement? So if it's a profit-sharing agreement and you're the one that's putting up the bail, shouldn't you also profit in that? Securities laws exist because of unique informational need of investors. They need your data elements to invest. That's what they're investing, is the data elements you give them. And if you don't give them, they still need them. Once you give them, they're in the game. They're in the profits because you ain't getting none. Securities are not inherently valuable. Their worth comes only from the claims they entitle their owner. their owner to make upon the assets and earnings of the issuer or the voting power that accompanies such claims. The value of securities depends on the issuer's financial management and the competitive regulatory climate. Securities laws and regulations aim at ensuring that investors receive accurate and necessary information regarding the type and value of the interest under consideration for purchase. That says under consideration for purchase. And yet not one of us has ever sold it to them. We just give it freely, not understanding the underlying obligations. For more information on securities laws, generally see securities. The rest of it's going to go into litigation and stuff, and you can read that if you want. But that's basically what securities are. They're an investment that has a risk, and the risk is that you ain't going to let them take the profit they think they're going to have. The risk is that you might know more than what they do. The risk is that you might be able to define certain things that they're not quite familiar with and are just pushing paper. They're just doing their job. Keep doing your job. So let's take a look. We already know what alleged is. And here's one of those funny ones that says allege. Says to allege means to claim or assert something as true. I want to ask you, if a comment etymologically is known to be invention, fabrication, or fiction, how can it be true? See all these people wanting to go around trying to profess it's true, it's true, it's true. What's true? Tell me. Tell me with your comments, written or spoken, they're still fiction. So the only way to have truth is to see it and hear it. Just because you speak it doesn't mean it's true. What's true is what you see and hear. And again, if you're hearing somebody else in their fictional words, that's not hearing, that's listening. Okay? So let's take a look at the next one. The next one is bailment. Bailment. Remember we were talking about an entity, and a person is somebody that can own property, has rights, titles, and interest in that property, right? Okay, so bailment, as the mentality of bail, a bailment is defined as non-ownership transfer of possession. Non-ownership transfer of possession. So does that mean that somebody other than the owner is transferring possession? Or is it the transferring of possession of the rights, titles, and interest in the property and not the ownership? See, they can't transfer the ownership. But what they can do underlying and underhandedly through the competitive contracts and the terms and conditions used, and of course, because people don't understand those terms and conditions, makes it underhanded. And they know this. They know most people don't know the terms. So if they know them and they can pass it on and say, hey, I need your name and address. I'm sorry. I believe if you're going to purchase something from me, that means I'm selling something. And as a seller, I get to give you a number in lieu of a name and address. 19 CFR 149.3. Don't know how else to tell you. It's that simple. It is a term and condition of contracting. It says buyer, seller, or shipped party can use a widely recognized, commercially identifiable number in lieu of a name and address. Yet we've all been taught to use the name and address, and not once have been told that we can use a number in lieu of that name and address. Oops. So let's take a look at it. Under English common law, remember that's the common law, not statute, not federal code. It's common law. This is your access to equity because equity is merged with common law. Okay? The right to possess a thing is separate and distinct from owning the thing. So as I said, it's not a matter of the ownership. You retain ownership. It's just that in all those documents that you sign as associative agreements for competitive contracts, profit sharing agreements is what they truly are, and you didn't get to share in the profits. Because that signature you gave, as I said, is an amendment to an insurance policy as an endorsement. If you go back in the videos here not too long ago, I went over endorsement, and it clearly says an amendment to an insurance policy. And as we saw, that security and everything, it's talking about risks. It's an investment, and there are risks. So they create the contracts as insurance policies. Okay? Interestingly, as a result of this distinction, in some jurisdiction, an owner of an object can steal their own property. In context, an owner who lends someone else an article, then secretly takes it back, can be stealing. When a bailment is created, the article is said to have been bailed. When a bailment is created, the article is said to have been bailed. When a bailment is created, the article is said to have been bailed. So why do you need to post bail? If that bailment is for the article, see what you do when you provide that bail bond? You're actually bailing the article. You're releasing the article. You're releasing the information to them so they can use it. If you don't release it, they're not supposed to be able to use it. So, 11 cases signed UCC 1-308 and then never appeared in court. And they still ain't going to come after me. They still haven't put any warrants out on those, despite the fact that they put a bench warrant out for failure to appear and slapped a $350 bond on it. Oops. Of course, I've got my dismissal on that. Of course, that's a dismissal. It's not a discharge. So in that dismissal, that little note that they sent me, they said court costs are taxed to the defendant. Oh, goodness. Taxed? Taxed? Isn't that an investment? You bet it is. See, they entered information that they already had on this, quote, Keith Little into their system so they could invest in it in a profit-sharing agreement. And then the guy that was supposed to share in the profits didn't show up, but they still want their profits. Mm-hmm. So instead of dismissing the bond, which is what the lady told me she would do, they just posted a note on the bond, and it didn't say dismissed. And then she provided a continuance as if though she had this personal jurisdiction. And she never did. There was no bail provided. There was no release of information. They were just digging into their old records, and they wanted me to go back into court and reaffirm it and say the same shit I've been babbling about through the other 93 cases. I'm not going to do it. I'm not going to do that anymore. That's what I'm urging everybody else to look up these definitions and find out where the error is. It's not in me, and it's not actually in the people that are proffering this stuff to you. It's in the record. It's in the words. So let's take a look again, because that's the article that contains all those words. One who delivers the article is the bailor. One who receives a bailed article is the bailee. So if at the hospital, through the enumeration at birth, the birth clerk has an article he is the bailor. He gave it to mom to sign and then took it back. And then he delivered it to the county registrar. So the birth clerk at the hospital is the bailor. Your mom is the informant that gave certain data elements relative to the article. Notice that's art. It's an artwork. And then when she signed it, that birth clerk took it down to the county registrar and registered it. That's a registered bailment. So let's take a look at the next one, which is bail bond. Now remember, under 18 U.S.C. 8, obligations and other securities of the United States includes all bonds. So again, I ask you, if all bonds are an obligation of the United States, why are they coming to you to post bail? Is there a displacement of obligation? If the United States, under 18 U.S.C. 8, is obligated on all bonds, then why is everybody doing this as if though it's their obligation? I only ask these questions because of the inconsistencies in the very codes that I read. And I'm telling you, folks, I've read damn near the entire U.S. code and CFR. I'm not the lazy one. I only put this information out not because I know the truth, but because I see the distinct inconsistencies that are the foundation of fiction. Period. If you guys don't catch on soon, the world's going to go right by you. You're going to be nothing but the dust, and you're going to live as dust. I had a little 6-year-old boy come up to me and another guy. We were in deep conversation, about this kind of stuff. And he interrupted our conversation because we were talking about death and things like that. And he said, you know, most people are dead their entire lives. This coming from a 6-year-old. I can't imagine how this world is going to destroy his mind by telling him, the same kid that when he went to school and they gave him this nice little toy looking thing with all the different colored shapes, and the teacher opened the top, took all the shapes out, put them on the table, and told him, okay, now we're going to test you. I want you to put those back in that box. So instead of taking one piece at a time, looking at it, and seeing that, oh, it fits in that one, and shoving it through that hole, he did the same thing the teacher did in reverse. He just took the lid up, put all of them back in, and said, there you go. Teacher turned around and said, no, that's wrong. Not in that little kid's mind, it ain't. Now what you've done as a teacher, in that little kid's mind, is you told him that he has to do things that are inconsistent with what he's seen. So let's continue on. Because as we see bail bond is an agreement to pay the court of if a criminal defendant fails to meet the terms of conditional release from custody. Many bail bonds are signed by the defendant and the defendant's sureties. Now wait a minute. Remember what we just talked about, that bail? Okay, so if there's a defendant and his sureties, is the defendant the surety? Or are there sureties? And who are those sureties? You see the language? You see the inconsistency? You can't be the surety if you are the one that granted the shit. You can't be surety if your mom is the one that granted it and you're the intended receiver. Goes against every grain in my body. And it says some bail bonds are signed by the defendant only, who may need to deposit money with the court as security for the bond. However, most defendants are financially unable to post their own bail, so they seek a written agreement with a bail bondsman. The bail bondsman acts as a surety by providing the money to the court. If the bail bondsman is the one acting as surety, then let him act as surety then. He who hateth suretyship is sure. And the scripture tells us we're supposed to be making bondsmaids and bond servants of them. Don't you get it? They're the heathens. By providing money to the court for the person's bail. Not your bail, the person. How come they didn't put down natural person? How come they didn't make the distinction of legal person or natural person? Huh? Don't you ever question this? Oh, wait a minute. No, of course you don't question it, because you don't do your fucking research. Why would you question it? You continue to just believe. Keep believing, bitch-ass slaves. Keep believing. So let's look at the next one. As it said, the bailor is the one that issues, and the bailee is the one that receives. Right? A bailor is a person or party who delivers a bailment. What is a bailment? Is defined as a non-ownership transfer of possession. So again, if the bailor, the birth clerk, issued the document to mom and she signed it as informant, and then he got it back and took it over to the registrar. That was a non-ownership transfer of possession of the bailment, not the property, the bailment. A bailer entrusts, a bailer entrusts. That's in trust. You can read that as in trust. In trust, as an entry. It's an entrance into trust. Personal goods or other property to a bailee until its restoration to the bailor. That entrustment is temporary, and the bailer only relinquishes possession of the good or property, not the ownership. In other words, a bailer would hand over the control of their personal property to the bailee. So again, I want to ask you if that document that the birth clerk gives to mom and has signed as an informant is the birth clerk's or the registrar's. Does it belong to the hospital or the county? In fact, it does belong to the hospital. And in fact, there are data elements on there that mom gave. She didn't sell them. No. She didn't sell them. She gave them, much like a gift. She granted them the knowledge. That is the foundation of every legal construct with your name. And it first was enumerated before they assigned the Social Security number. With specific purpose. Example, safekeeping. Based on their agreement on the matter. See, all those terms we saw earlier about that shared a profit sharing agreement with security and all that, possession and ownership. It's all right here, folks. It's all right here. Bailer and bailee. So let's, and another one. We're going to look at the other two here in a minute, but we're going to continue on with this one because it's got a nice little term in here that I want everybody to see. And it says sometimes a bailer is not the owner of the property, but a keeper for the owner or a finder who puts the property in the hands of the bailee until the owner is identified. Again, that document was signed by mom as an informant, and it was a transfer of benefits for you. It was a benefit of ownership for you. Okay? It's your property. It's not the hospital's. The paper, the commercial paper, is the hospital's. Mom granted information for that piece of paper that was then entrusted, creating a trust. Like I said, and you can look it up in your state, burial trust, Minnesota code, burial trust, Iowa code, burial trust, or something like that. You should be able to find it. And that is so that if the child dies, the state will take care of the burial. If mom dies before the child turns 18, the state will take care of the life of the beneficiary. And of course, That's all based on the idea that there is no father. Okay? A bailer must act with good faith. Good faith. What is good faith? Good faith is a broad term that's used to encompass honest dealing. Depending on the exact setting, good faith may require an honest belief or purpose, faithful performance of duties, observance of fair dealing standards, or an absence of fraudulent intent. A fiduciary relationship creates a duty of good faith between the agent and the principal. The breach of this duty of good faith can lead to liability. Failure to act in good faith is known as bad faith and is generally considered to be a level of culpability greater than negligence. A party is liable when they are held legally responsible for something. Unlike in criminal cases where a defendant could be found guilty, a defendant in a civil case risks only liability. Okay? Only liability. Why do you think all these traffic cases are processed as criminal cases? Because they don't want you to catch on that it's just a liability. And like I've said, for many years now, it's all a big insurance scheme wherein you take on the obligation of being a surety. And that's not what you're supposed to do. That's what the insurance is for. So if there's insurance, why are you being held as the surety? Because it's a criminal case and not a civil case. No, there's only one form of action, and that's civil. Oops. It has to be entered as a civil case so they can provide a civil remedy in case somebody makes false accusations of a crime when there really was no crime. It was just an infraction. It was just a matter of mere negligence and not a crime. So let's go back. Interacting with the bailee. And the bailer can at least benefit from the performance of the duty in good faith from the bailee. A bailer is also a person who provides bail as a surety for a criminal defendant's release. So if a bailer is the one that delivers a bailment, is also a person who provides bail. Bail is the money a defendant pays. So if you pay bail, then you are the bailor. And the bail bondsman is the bailee. That bail bondsman, as it said earlier, is required to give that bailment back. Okay? Let's look at the next one, guys. Bailee, as opposed to bailer, says a bailee is a person who receives property from the owner, known as a bailor, and holds the property for the owner for a particular purpose, such as custody or repair. Some examples of this include storage companies that hold people's belongings, a dry cleaner holding someone's clothing, and a mechanic holding someone's car for repair. The bailee does not obtain ownership rights to the property and must return the property when the contract has been fulfilled. So when you pay bail, you are the bailer, and you gave it to the bail bondsman as the bailee, and once the contract has been fulfilled, they're supposed to return the property, must return the property. The money is the property you gave the bail bondsman to assure that you would appear in court. Once your appearance is done, you're supposed to go back to the bail bondsman. Hey, I need my money back. They're supposed to give you your property back. That money is the property, right? And you gave it to the bail bondsman as bail, as the bailee, or excuse me, bailer, and he's considered the bailee. And it says in their own codes that he's supposed to give that property back. How come you never got that property back? When the contract has been fulfilled. So what about the bail in a criminal case? Again, folks, if you don't understand it, there is one form of action, a civil action. There are two different procedures in that civil action. One is civil and one is criminal. But there's only one form of action, civil. This is the same thing with equity. If you want to reach a court of equity, it doesn't matter what your equitable remedy is if it's not a contractual setup. Even in equity, you have to understand contract terms and conditions so you can provide for your private relief law through that remedy so that that stuff doesn't happen again. All these contract terms and conditions that they're using against you, they'll keep using against you if you don't access the court of equity and establish your own private relief law. They will hold you subject to the public law, as it said earlier, without your consent. That's how it operates, folks. But again, they can't do it without your consent. They can only do it without your consent if you believe that. Once you know the truth and you start changing the intent, it changes their ability to accept. See, it goes by the purpose of the use of the property. Every piece of property has a purpose. A hammer's purpose is as a hammer, not a screwdriver. Okay? And each one of these terms has their own purpose. Yes, Joseph, what a mess. What a mess. And it goes on to say, the bailee must also practice ordinary diligence while the property is in their possession. They can be held responsible for any gross negligence that occurs. And now we're going to come up on the last one where we talk about the custody. That's that transfer of possession of the rights, titles, interest, and use, and not the actual ownership of the property. Bailee. Notice it's got custodian. So when you are a bailer and you give a bailee some of your property, they have it in their custody. They are known as a custodian. If it's foreign property, not for them and not part of their association, then they are deemed a foreign property custodian. Bailee is a person who receives possession of a property or goods, usually pursuant to a contract of bailment. A contract of bailment. So when Mom signed as informant on that commercial paper at the hospital, that was a bailment. And she gave her data elements as a gift. She's not the one that's getting it back, but that gift was meant for me. See, that bailment was the establishment of a legal entity, a presumption of facts that was placed on the record. That's a legal fiction, because all of those facts that are on the record are comments known as inventions, fabrications, and fiction. A bailee is responsible for the safe return of the property or goods to the owner, bailer, when the contract is fulfilled. Unlike a contract of sale, the bailee has to return the goods or property to the bailer under a contract of bailment. A bailee is also referred to as a custodian. So a custodian can also be determined as a bailee. So the county registrar that has property that doesn't belong to them, no it don't. That name on there doesn't belong to you. None of those names on there belongs to that county registrar. None of those names belongs to any entity. The names belong to the people that own them. Okay? 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 Yeah. See, that is my name, but it's been altered grammatically. And then I was never taught the proper grammatical construction in their public education system. I had to learn that from the Amish. So let's see if we got anything else left here. Oh yeah. Examples include banks holding bonds, storage companies where furniture or files are deposited, a parking garage, or a kennel or horse ranch where an animal is boarded. So again, we see just like the auto mechanic that has your car in the shop overnight, or even just for a few hours, he's a custodian of foreign property. It's not his property, but you've given it to him for a certain temporary period of time so he can fulfill an obligation based on the contract that you signed with him. That's as simple as it gets, folks. All you have to do is fulfill the contract. What is the fulfillment of the contract in all of this? Well, like I said, the enumeration at birth was the establishment of a legal fiction. And that legal fiction, as designed by the United States, a capitalism, competitive contracting, you have to quit using their person and their legal foundation. You have to create your own. That's their creation. You have to learn how to create your own. And that means to come up upon age of majority, and rather than signing an SS5 and letting them and telling them in that contract, I'm going to give you my estate until the finalization of the contract, you don't contract that. You learn from your mom and dads, and this is why it's important for moms and dads to teach their children and not this public education system, because the public education system isn't going to teach you how to do this. Okay? So instead of filing the SS5 at the age of 18, if your mom is still alive, she and you should go down to the county registrar and remove that document. It's got her name on it. She signed it. She's one of the owners. And guess what? if the secretary of the hospital or whoever else signed it, they don't have ownership of the document and the information. They only have ownership of the process, the legal process. That's the only part they play in this. So again, not something I've done, but my interpretation is that when you turn age of 18, age of majority, instead of filling out the SS5 and handing those estate matters over to the state, you go down to the county registrar and you remove that, you collapse that trust and transfer all the monetary value that's in it to a private estate. Now, whether mom and dad have their own private estate set up in a private trust and then have a revocable trust in your name within their irrevocable trust, that would be, I imagine, the best setup. That way you could just take that property and establish it for a new revocable trust as you continue training that adult now, that young adult, in the furthering of learning the contracts and otherwise as he becomes practicing in them. Otherwise, you're not learned yet. And by signing the SS5, you ain't learned. You've shown that you don't want to learn, or that there's nobody in your life willing to help you to learn, or has any interest in helping you learn. And so, yeah, I agree and admit that you're probably left at your own devices to do the best you can. And most people assume that the state wouldn't do such things to their people, such as throw them in jail for a bailment when there's sureties or co-sureties and they've got your fucking property. I don't see how anybody can believe that some kind of legal system, which is based on legal fictions, which is a presumption of facts presented to the court until properly rebutted, which doesn't mean you bring truth. It means you bring greater facts that subdue the bullshit they're trying to pose. It's like when my mom stands there and tells me, Keith, the police are your authority. No, Mom, God is my authority. Anyway, I really hope you guys understand. What this country started out as was a republic form of government based on a confederacy and then operated as a democracy and administrated as a capitalist society. This is why we have a United States, which is a corporation, and that corporation provides all of these terms and everything we're looking at here. That's LIIWEX, Cornell Law. That's the U.S. Code and Code of Federal Regulations. And all of these terms here on these other LI, that's according to those definitions in those codes. It's not a federal government. We don't have such a thing as a republic form of government. This federal government means all entities of the government of the United States, including the United States Postal Service, the registered agent already, and the Postal Regulatory Commission, meaning the Postal Regulatory Commission is the grantor, grantee, and the Postal Service is the registered agent, and the United States, which is a corporation, is the beneficiary. Under that, you claim you're a United States citizen when there's no such birth registration to prove that a single U.S. citizen was ever born anywhere in the United States or any of the states of the Union. There's not one shred of evidence of it, folks. Not one. So we see the United States as a corporation is capitalism, it's competitive contracting. And if you don't learn how to contract, which is negotiate, then you'll never understand negotiable instruments and your power in those. You will forever keep signing and amending insurance policies that will put your name as the surety. Keep on, suckers. Keep on. Keep believing. Keep being lazy. Don't do your research. Keep listening to people like me and not understand us because you still refuse to do your research. Because, see, me sitting up here reading this to you isn't giving you comprehension. I can explain it to you, but I can't comprehend it for you. This is why I hate sitting up here all by myself. All you people down there in the chat and everything and watching, and not a one of you wants to ever come up and chat with me on panel so we can discern things for yourself, and I can get different objective views that might help point out where I might be wrong. So in the meantime, my head does this as I think, well, obviously I must be right then, because ain't nobody denying it. I will tell you, though, I do think I have a great discernment. Been reading all my life and doing the best I can to comprehend things on my own. And when I can't, I do ask questions. And I don't ask them just once, and I don't ask them of just one source. Yes, it's a military. Yep, military. And that's why I say it's a matter of giving that bailment over and letting them know. See, at the age of 18, young men sign up for Social Security and SS selective service. Okay? And that's because they've already, upon the age of 14, when they could have quit school voluntarily, they volunteered to continue on. And maybe not so much volunteer because mom and dad threatened them that if they didn't continue on with school, they'd get the fuck out. So most people are induced by their very own parents to keep on with that public education system. And this is just abhorrent. You're destroying your children by doing so. And then when they're 14 and they start kicking back and telling you don't want to go to school no more, you want to sit there and enforce that they better. They better. You can't get a good job without a good high school education. You know how many people in history never even went to school? Oh, goodness gracious. Jesus didn't go to school, but he did have the innate drive to learn. And that's the problem. See, we send our kids to school and they end up hating learning. And that's the inherently the most powerful thing in our lives is our ability to learn. That's what makes us different than all of the other creatures. So anyway, I hope going over these terms kind of helps you realize the ambiguous nature of all these different codes and everything and how it works. Every piece of paper is known as commercial paper. That's a commercial construct. There's only one form of action, civil. And that is the preclude or the presumption that places that they can bind you without your consent. And that's false. You have to get out of this belief system so you can start learning how you can place your terms of negotiations on the documents so that if they do believe they have your consent, you have a say in it and you will share in any profits. See, contracts, any contract, not just competitive contracts, but any contract, every contract is based and founded on the principles of equal consideration and equal benefit. And if there is detriment, then it too is shared. Contracts are based on sharing. So when they provide these commercial papers, and instead of sharing profits with you, they call them fines, fees, penalties, court costs, surcharges, taxes, and all this, then there's something seriously wrong. And I guarantee you, folks, I'm not insane. I'm not the absurd one. I've had a competency test 3 times. And those competency tests, they're done by doctors. See, doctors have more authority than the court judge. See, the doctor's the one that started all of this. Without the doctor, there is no legal fiction. See, if you have a home birth and they don't know about it, then there's no construction of a legal fiction because there's no doctor involved. And again, just to clear the air, I don't think you should go to hospitals. I'm not saying you're not supposed to. I'm not saying you can't. I'm not saying it's illegal, unlawful, or anything. I'm saying I don't think you should. And I'm going to tell you why. There's not one other creature on this planet that seeks out a doctor to give babies. It's a natural act. That's a true art form. There is no authority but that which is ordained by God. If they don't have consent by God, then it's not true. So a legal system that tries to say that they can contract you and bind you without your consent is false. I urge you to learn this stuff and learn how to stand on your own 2 feet so you can contest this stuff. Don't complain about it. Don't make false accusations. Contest it. See, that's what this whole life is. It's a big test. And if you want to be competitive in contracting, then look forward to contests. That's what they are. A contest is where you enter into something and get a reward. Amazing how that works. Bail, bailment, bail bond, bailer, bailee, and bailee is the same as a custodian. And whoever handed that document over after Mom signed it, because it doesn't have any value without Mom's signature. That says Mom's the true owner. And see, they can't just hand out a document that's got 2 signatures on it already and say, here, I need you to fill this out and sign it. They could, I imagine. But that's not the way it works. They hand the instrument to you, and then you have to give them something. That's a purchase. In the basic terms of purchase, means to grasp. You have a purchase on the land. It's not buying and selling. So think about this stuff, and I urge you. You better unlearn the shit that you've been filled with to remember and start actually learning. Unlearn all that stupid shit and start learning what's truthful, what has a greater truth in it. Otherwise, you're going to continue to live a lie. And that's disgusting. Full-grown boys and girls that know better. And rather than be truthful and honorable, they will continue to live a lie like most people and say, well, I don't know what to do about it. Again, unlearn what you've been taught and learn what is truthful. That's what you do about it. That's the first step. And if you refuse to do that, you're the sucker. You're the sucker that's going to keep signing documents knowing that they're endorsements, because I told you and showed you an endorsement is a amendment to an insurance policy. And every time you sign one of those commercial papers, whether it's considered a security or not, there's a risk. There's a risk in you signing it. That's the risk. That's insurance. Believe me or not, I don't care. Matter of fact, I'm telling you not to believe me. Don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud. Don't believe your mother. Do your fucking research. Anyway, that brings us to the end of our night. I appreciate everybody's support. I want to thank everybody for showing up. Again, I really wish I would have people come up on panel. I need your input. I've got over, I think, 850 videos now. I'm probably about done if I can't get any objective views and stuff. I'm going to have to go search for them somewhere else. So in the meantime, I do appreciate your help. I do appreciate your support. I do appreciate you at least listening. So just know that I love you. But again, I don't give a rat's ass whether you love me back or not. And that's to say, I don't care if you hate me. If you love me, great. That's fine. That's what you're supposed to do. That's what I would expect. So in the meantime, may God bless you and have a good night.